Picture your last closing. Now count the documents you signed that you did not write. The title commitment came from the agency. The closing instructions came from the lender. The deed package came from opposing counsel. The payoff letter came from a servicer you have never spoken to. You reviewed them. You signed them. Your signature turned someone else's work product into your liability. On June 10, 2026, a Georgia judge found out what that conversion costs. Hi, if we haven't met, I'm attorney for Juniata's digital avatar. She writes every script I bring you on this channel to ensure you have the human-led oversight and 20-plus years of closing table experience needed to keep your firm ahead of the game. Juniata has spent her career at the closing table running zero-error transactions. She knows what happens when a system fails. Let's focus. On June 10, 2026, the Georgia Court of Appeals vacated a Title VII ruling. The case is Henry County Schools versus Grant, Georgia Court of Appeals, 2026. The trial court had signed a proposed order. That order was drafted by a party's attorney. It relied on at least one hallucinated case. A hallucinated case is one that does not exist. The panel called the submission troubling. It called the trial court's failure to catch the errors before signing regrettable. Follow the sequence. The party's attorney drafted it. The judge signed it. The appellate court vacated it. Nobody in that courtroom typed a prompt. The defect still arrived. It still had consequences. Here is the problem with most firm AI policies. They govern what your staff types into a tool. Very few govern what arrives already drafted. That gap is where shadow AI enters a real estate finance practice. In plain English, unvetted AI output walks into your file, and it does not come from your associates. It comes from your counterparties. Count the adoption points in one transaction. Proposed and consent orders from opposing counsel. Title commitments and curative documents from the agency. Lender closing instructions. Vendor payoff and survey correspondence. Client entity documents and prior counsel work product. Every one of those was drafted somewhere you cannot see by someone whose AI practices you have never vetted. You do not have to use AI to answer for it. You only have to adopt its output. Illustrative scenario, not a real matter. Borrower's counsel sends a consent order Thursday, so the loan can close Friday. It recites Georgia Lien Priority Authority. It reads clean. You have a wire deadline and an underwriter waiting on you. You sign it. You file it. 6 weeks later, one of those cases turns out not to exist. The order is yours now. The document that failed was the one you never questioned because it came from a lawyer and not from a chatbot. 3 steps. None of them require new software. Step 1. Inventory your adoption points. Walk one closed matter start to finish. List every document that arrived already drafted. Name the source. Mark every one you sign, file, record, or forward. Step 2. Extend the policy past your own staff. Add an adopted work product clause to your AI acceptable use policy. Define adoption precisely. Signing, filing, recording, or forwarding under firm letterhead is adoption. Require independent verification of every authority cited in anything the firm adopts, without regard to who drafted it. Step 3. Build the verification record. Log which authorities were pulled, from which database on what date. A note that says reviewed proves nothing. Assign a named reviewing attorney to each adopted document. Anonymous review is no review. Route the record into your quarterly governance review. Undocumented compliance is not audit-ready compliance. Georgia courts have already acted. Shahid versus Essam, Georgia Court of Appeals, 2025. The court imposed the maximum available sanction for a filing built on citations that were fake or unsupported. In 2026, the Georgia Supreme Court vacated an order denying a new trial in a murder case That order was largely prepared by the prosecutor. It cited cases that do not exist. The court suspended her from practice before it for 6 months. Same mechanism. A judge signed a document someone else drafted. Rule 3.3 governs candor toward the tribunal. Rules 5.1 and 5.3 govern supervision. Rule 1.1 governs competence. If you cannot account for how a document in your file was produced, competence becomes a fair question. Georgia is not watching this from a distance. Georgia is generating the case law. Most firms find the adopted document gap the way that trial court did, after the fact, in someone else's opinion. The AI Liability Quiz sorts your firm into one of 3 tiers in under 5 minutes. Statutory Time Bomb, Fragile Hybrid, Digital Fortress. Each tier comes with the exposure that put you there and the correction that moves you out of it. Link is below. Find out which documents on your desk are already yours. I'm Attorney Ford. Build the foundation. Protect the practice.